Name the campus, Ms. Ruiz said, and for the first time that afternoon, the state's blood spatter expert stopped talking. He had been speaking for nearly 2 hours. Until that moment, he had owned my courtroom. He stood in that witness box in a charcoal suit with a silver tie and the easy arrogance of a man who had spent years being mistaken for intelligence. His charts were lined up on easels. His laser pointer rested in his hand like a conductor's baton. Every sentence came wrapped in jargon. Every answer grew longer after the question ended. He did not testify. He performed. And when Ms. Ruiz asked him to name the campus of his Ph.D., the prosecutor was on his feet before the last word landed. Objection, relevance. I looked at the witness. He had just finished telling 12 jurors that the defendant's account of self-defense was scientifically impossible. A man's life was sitting at counsel table because this witness had dressed speculation in technical language and called it certainty. Relevance was not the problem. Overruled, I said. He may answer. The witness adjusted his glasses. He reached for the water. His hand missed the glass the first time. That was the moment most people remember. It was not the beginning. The beginning was uglier. When court resumed that morning, the state called Dr. Adrian Kessler as its final witness. Doctor came first every time the prosecutor said his name. Never once, Mr. Not once. That detail mattered more than some people in that room understood. The defendant, Daniel Mercer, had admitted he fired the shot. There was no mystery about that. Daniel had not hidden, had not run, had not changed his story. He called 911 himself. His voice on that recording came in gasps and fragments. He said a man had broken into his house after midnight. He said the man came through the kitchen door with a pry bar. He said they struggled. He said he thought he was going to die. Then he fired. Self-defense cases are not clean. People imagine a bright line. They imagine a villain entering under a spotlight and a victim responding with perfect geometry. Real violence does not arrive organized. It crashes through a doorway and leaves broken things where it finds them. Daniel's wife sat behind him that day with both hands locked around a folded tissue that never left her grip. His younger brother sat beside her, leaning forward so hard through the morning that I thought he might stand without permission. Daniel himself barely moved. He listened like a man listening to his own burial. Dr. Kessler made it sound simple. He told the jury the blood on the cabinet, the stove, and the lower cupboard doors proved the intruder had already turned away when Daniel fired. He said the droplets formed an angle inconsistent with close struggle. He said the directionality of the stains showed forward projection. He said the distribution pattern showed a controlled discharge from an advancing shooter. He said those words slowly. Controlled discharge, advancing shooter. Then he pointed his laser at a photograph of Daniel's kitchen, and the red dot trembled over a row of tiny stains on a white cabinet door. These are medium velocity impact spatters, he said. They are not transfer. They are not cast off. They are not expirated blood. They are impact stains, resulting from a projectile entering tissue, while the source is moving away from the shooter. He paused there, not because he needed to, because he knew how a pause works on a jury. The prosecutor took 2 steps toward them and lowered his voice. Doctor, in your expert opinion, was the decedent backing away when he was shot? Yes. Could the defendant have fired that shot while pinned in close quarters, as he claims? No. He did not say, I don't believe so. He did not say, it is less likely. He said no. You could feel the room shift. If you have never watched bad science take hold in a courtroom, let me tell you what it looks like. It looks like shoulders dropping at the defense table. It looks like jurors who have spent days trying to follow ordinary witnesses, suddenly grabbing onto the first person who sounds certain. It looks like a lawyer objecting twice, then sitting down because every objection makes her look afraid of the answer. It looks like the truth getting quieter with each technical word. Miss Ruiz fought him. She fought him from the moment he opened his mouth. Objection, foundation, overruled. Objection, misstates the physical evidence, overruled. Objection, narrative. Sustained briefly, and then the prosecutor asked the same question in shorter form and got the same poison into the record. That is how it happens. Not with one dramatic blow, with inches. Dr. Kessler had credentials on paper that looked respectable enough to get through a gate. He had testified before. He had completed courses. He had listed associations. He had written Ph.D. after his name everywhere that mattered. The state had tendered him as an expert. I had allowed the voir dire. Ms. Ruiz had challenged him. I had heard both sides. On the record, I had grounds to admit him, and so I did. A judge is not free to act on a raised eyebrow. Remember that. People like to imagine we can stop a lie the instant we dislike its shape. We cannot. We act on evidence, not instinct. Sometimes that means means you must sit still while a fraud borrows the dignity of the court to sharpen his knife. And Dr. Kessler sharpened it carefully. He enlarged the photographs. He overlaid arrows. He traced the alleged path of droplets with such confidence that one juror began nodding before he finished his sentence. He turned Daniel's kitchen into a diagram and Daniel's panic into a theory. He said the victim's left shoulder angle proved retreat. He said the absence of backspatter on Daniel's shirt proved distance. He said the blood near the sink suggested repositioning after the shot. He said the defendant had time to create a narrative. That phrase landed exactly where the state wanted it to land. Daniel lifted his head for the first time all morning. Not much, just enough to stare at the witness. Ms. Ruiz rose for cross-examination with a yellow legal pad and the look I have seen on good trial lawyers when the ground is moving under them, but they refuse to step back. She started where any careful lawyer starts: compensation, prior testimony, assumptions in methodology, limitations in the underlying photos, whether he had personally visited the scene, whether he accounted for post-incident movement by paramedics and officers. He brushed through all of it. How much are you being paid for your testimony today, doctor? My rate is standard. That wasn't my question. $450 an hour. For review? Yes. For testimony? Yes. For travel? Yes. And how many hours have you billed? I'd have to check my invoice. You don't know? I don't carry my accounting in my head, counsel. A few jurors smiled. He knew they would. She pressed on. You never visited the Mercer home, correct? I did not need to. You based your reconstruction on photographs taken after officers entered, after EMS entered, after the body was moved for life-saving efforts, correct? I based my reconstruction on the available evidence. That's not an answer. It is the answer. The prosecutor, objection, argumentative, sustained. The witness gave her nothing clean. Every admission came wrapped in contempt. Every narrow question brought a broad answer. He corrected her pronunciation once. He corrected the prosecutor never. That matters too. By noon, the room looked like his. Daniel looked smaller. Miss Ruiz had won details but lost momentum. The state sat back with the satisfaction of people who think they have purchased certainty wholesale. One juror had begun writing down his phrases exactly as he said them. Controlled discharge, advancing shooter, scientifically impossible. That is when I noticed Ms. Ruiz stop asking about blood. It was a tiny thing. She had been moving through crime scene photographs in order. Then she reached his curriculum vitae, glanced at page 2, and went silent for 3 seconds too long. She looked down again. Her thumb held a line. She asked one more question about certification. He answered with a list of organizations so long it sounded like he was reciting train stations. She let him finish. Then she asked for a recess. The prosecutor objected immediately. Your Honor, we're in the middle of cross. I can see that, I said. She's breaking the flow of examination. Ms. Ruiz did not look at him. She looked at me. 5 minutes, Judge. What for? For something I need to verify. The prosecutor spread his hands. This is gamesmanship. Dr. Kessler leaned back in the witness chair with the smile of a man who believes breaks only help the loser. I watched Ms. Ruiz for a moment. Trial lawyers ask for many things they do not deserve, but the good ones have a look when they have found a thread and are afraid it will snap if they speak too soon. She had that look. 10 minutes, I said. The prosecutor began again. Judge, 10, I stood. Members of the jury, do not discuss the case. When I returned to chambers for that recess, I did not have facts. I had unease. There is a difference. Unease is common. Facts are rare. I reviewed my notes. I looked again at the exhibit list. I looked at the witness resume that had been marked for identification but not published to the jury. Ph.D. in forensic hematology, Rutherford International University. That was the line she had stopped on. I had never heard of it. That alone meant nothing. The world is crowded with institutions I have never heard of. Still, the name sat badly. Rutherford International University. It sounded manufactured, not false. Manufactured. There is a style to fraud. Too polished, too complete. I had no business investigating from the bench, so I waited. When we reconvened, Ms. Ruiz did not return to blood patterns. She walked to the lectern with 3 printed pages in her hand and a quietness that changed the temperature of the room. Dr. Kessler, she said, you testified on direct that you hold a Ph.D. in forensic hematology, correct? Yes. From Rutherford International University. Yes, name the campus. The prosecutor was up in an instant. Objection, relevance. And we are back where I began. I overruled it. The witness reached for the water and missed. Doctor, Ms. Ruiz said again. He cleared his throat. The institution was primarily distance-based. That wasn't my question. Name the campus. It has administrative offices. Name the campus. The prosecutor stepped closer to the bench. Your Honor, may we approach? No. I kept my eyes on the witness. Answer the question. He shifted in the chair. The program was international. Doctor, Ms. Ruiz said. Isn't it true Rutherford International University has no campus? The prosecutor hit the table with his palm. Objection. Overruled. The witness tried a smile. It came out crooked. Many modern institutions operate online. So that's a yes? It operates through distributed learning. Does it have a campus? He looked at me. That was his mistake. Witnesses who lie under pressure often search the room for the one person they think can rescue them. In my courtroom, there is only one person they should never look to for rescue when the truth is under oath. Answer, I said. No, he said. You could hear paper move in the jury box. Ms. Ruiz did not hurry. Good lawyers do not sprint at an opening. They widen it first. So when you testified that you earned your Ph.D. from Rutherford International University, you meant you paid for and completed an online program? I completed rigorous coursework. On a campus that does not exist, the prosecutor. Objection, mischaracterizes. Sustained as to form. She nodded as if I had helped her. There is no physical campus, correct? Correct. Any laboratory? Our work was conducted through remote modules. Any dissertation defense in person? There are alternative academic models. Did you ever defend a dissertation before a faculty committee in person? No. She took one of the pages in her hand and turned to the jury, but not enough to show them. She was baiting the next objection. She got it. Judge, may we approach? The prosecutor said again. No, Mr. Halpern. Sit down. He did not sit immediately. That told the jury more than he intended. Ms. Ruiz continued. Doctor, I'd like to ask you about Rutherford International University's accreditation. Accredited by whom? It is recognized internationally. That wasn't my question. It is recognized by independent educational bodies. Name one. He hesitated. Name one accredited body recognized by the United States Department of Education. The witness shifted again. That depends on the jurisdictional framework. She did not blink. Name one. Silence. The prosecutor rose halfway. Objection. Counsel is testifying. Overruled. The witness looked down at his hands. I would need to review the exact institutional documentation. Ms. Ruiz held up the printed page. Would it help if I told you Rutherford International University says on its own website that it is not accredited by any agency recognized by the United States Department of Education? The prosecutor was fully standing now. Objection, hearsay, authentication. Do you dispute it, doctor? She asked without looking at the prosecutor. He opened his mouth and nothing came out. That was the first crack the jury could see. If you think that ended him, you have not spent enough time around professional fraud. Men who build a life out of borrowed titles do not collapse at the first touch. They pivot, they rebrand, they accuse the room of being too small for them. Dr. Kessler sat forward and straightened his tie. Accreditation politics have long been weaponized against non-traditional institutions, he said. There it was. Not an answer. A cloud. And yet, Ms. Ruiz said, you used Ph.D. on your reports, your invoices, your website, your testimony, and your sworn resume to this court. Yes. Without noting that the institution is unaccredited. My education is real. Is the institution accredited? He stared at her. No. The prosecutor asked for a sidebar. I denied it. Then Ms. Ruiz pulled the second page from her stack. Doctor, before becoming a blood spatter expert, you worked in residential real estate, correct? His head turned sharply. Objection, the prosecutor said, forgetting for a moment that objections are not the witness's privilege. Counsel, I said, and he sat back down. The witness answered anyway. I have had several professional roles. That's not my question. Yes, I worked in real estate. For how long? A number of years. 10, approximately. And during those 10 years, were you ever employed by a crime lab? No. By a medical examiner? No. By a police department? No. By a university? No. She took one step closer. So before you started calling yourself a forensic consultant, your primary occupation was selling houses. He lifted his chin. There is no dishonor in honest work. No, she said, there is dishonor in fake expertise. The prosecutor shut up. Objection, moved to strike. Stricken as to the last phrase, I said. The jury will disregard counsel's characterization, but the room had heard it. Once a word like fake lands, it does not leave on command. Ms. Ruiz pivoted before the witness could recover. Your real estate license expired 6 years ago, correct? I transitioned fields. It expired after you sold 3 homes in 18 months. Objection, the prosecutor said again. Overruled. I'll allow limited inquiry into professional background as it bears on expertise. The witness tried to regain altitude. People enter forensic work from many disciplines. Real estate, analytical disciplines. Open houses prepared you to reconstruct homicide scenes? He sneered then. Not at her, at Daniel, at the whole defense table. Observation prepares you. That line sat in the room like a smell. Daniel's wife put the tissue down for the first time and folded her arms. Ms. Ruiz held up the 3rd page. Dr. Kessler, is this your professional website? I'd have to see it. She approached the witness with permission. He looked at the page. Color moved out of his face. Yes, he said. On the home page, under your biography, does it say you are a world-renowned forensic hematology scholar? I may use marketing language. Marketing language? Yes. Just below that, does it list your doctoral institution? Yes. And just below that, does it offer private consulting packages in tiers labeled bronze, silver, and platinum? He said nothing. Answer, yes. Somewhere behind the rail, somebody let out a breath that sounded almost like a laugh, and then swallowed it when I looked up. The prosecutor stood again. Your Honor, we are drifting into collateral matters. We drifted there when your witness used academic credentials as the spine of his expertise, I said. Sit down. He sat. That was the first time I had spoken with any edge. Not much. Just enough. A courtroom hears tone the way a forest hears axes. Ms. Ruiz turned a page on the lectern. Doctor, on your website, under professional experience, do you list yourself as former lead forensic analyst for multiple agencies? I have consulted widely. That wasn't my question. I have assisted investigations. Were you ever employed as lead forensic analyst by any agency? No. Any agency at all? No. Did any accredited university confer upon you an advanced degree in any forensic science? No. Did any accredited university confer upon you any degree whatsoever? He licked his lips. No. You could see the jury trying to reconcile the man in front of them with the man they had listened to for 2 hours. That is the violence of lies in court. They do not just attack the accused, they conscript the audience. The prosecutor tried one more move. He rose slowly this time, as if calm itself might repair the damage. Your Honor, even if there are issues with the witness's academic background, his testimony is based on his training and experience. Ms. Ruiz spun before I could speak. Training from whom? Counsel, he said. No, I said. She may ask. The witness swallowed hard. Doctor, Ms. Ruiz said, who trained you in bloodstain pattern analysis? I completed advanced forensic modules. Through Rutherford? Yes. The same unaccredited website. It is not a website. It is an institution. She pulled another paper from the folder. I had not seen her pick it up. Good trial lawyers hide the blade until they need it. Doctor, is this a screenshot from Rutherford International University advertising life experience doctoral pathways? The prosecutor lunged back to his feet. Objection, foundation. Doctor, she asked. He stared at the page. I can't verify where that came from. She placed it on the document camera. Now everyone could see it. Not an ivy-covered gate, not a faculty building, not a laboratory, a web page with stock photos, smiling models, and a banner offering accelerated doctoral recognition based on professional achievement. The prosecutor moved for a mistrial. Not quietly, not carefully. He said it standing, voice tight, with his hands already gathering papers as if flight might outrun record. Your Honor, this has become prejudicial beyond repair. Ms. Ruiz answered before he sat. Prejudicial to whom? Enough, I said. The room froze. I looked at the witness. Did you obtain your doctorate through this institution? It's more complicated than that. Did you? I completed their requirements. That is not what I asked. His mouth worked once, twice. Yes. Did those requirements include the purchase of credit for life experience? The prosecutor said, "Judge, I did not take my eyes off the witness." Did they? Yes. No one moved. Then Ms. Ruiz asked the question that finished the job. "Dr. Kessler, how much did you pay for your Ph.D.? He looked at the prosecutor. The prosecutor looked at me. I looked at the witness. "Answer him no," the prosecutor said under his breath. "Too low for the transcript perhaps, but not too low for the room." That was the moment the ugliness showed its full face. Not the fake degree, not the bloated resume, the instinct to preserve the lie after everyone could see it. "Doctor," I said, "you will answer the question." He spoke so softly, the court reporter asked him to repeat it. $2,900. "Louder," I said. $2,900. Ms. Ruiz did not pounce. She let the number sit there. $2,900. Less than some people spend on a used sofa. Less than the state had probably paid him to testify. A man's liberty had nearly been buried under a degree that cost $2,900 and a few clicks. If you are still with me, hold on to that number, because what came next is why courts cannot afford vanity in the face of fraud. The prosecutor tried to rehabilitate him. He stood for redirect with a stiffness that looked painful and asked whether non-traditional education invalidated years of independent study. He asked whether Dr. Kessler had attended seminars. He asked whether practical experience could matter more than institutional prestige. He asked whether criticism from the defense changed the blood evidence itself. The witness grabbed at each question like driftwood. "Yes, I studied extensively. Yes, I have reviewed many scenes. Yes, science is science." And then he made the mistake that ended any possibility of rescue. He looked at the jury and said, "This is all a distraction from the fact that the defendant shot an unarmed man who was retreating." Unarmed. Daniel stood up so fast his chair scraped the floor. "Prybar," he said, not shouted, said, one word, raw and direct. His lawyer pulled at his sleeve. The prosecutor objected. The bailiff took one step. The jury jolted. The witness kept going, because liars who survive too long begin to think they are bulletproof. "There was no evidence of a meaningful threat," he said. I struck the gavel once. "Stop." That word was for everyone. Then I turned to the witness. "You will not editorialize. You will answer questions asked." He sank back, but the damage was done. But not to Daniel, to himself. He had crossed from inflated expert to advocate. Jurors know the smell of partisanship, even when they do not know the law. Ms. Ruiz stood. "Your Honor, I renew my motion to strike the entirety of this witness's testimony." Mr. Halpern was up before she finished. "Judge, that is extreme. Any issues go to weight, not admissibility. Weight, not admissibility. Lawyers say that when they want the jury to sort through rot because they are afraid the court will throw it out whole. I asked for the witness's resume, the website printouts, and the accreditation page. I read them in silence while the room waited. No one coughed. No one shuffled. Even the air seemed to hold itself still. Then I asked one question of my own. "Dr. Kessler, where did you defend your dissertation?" He blinked. "It was submitted electronically." "That is not my question. Before whom did you defend it?" "There was an evaluation process." "Name one member of your committee." He opened his mouth. Closed it. Opened it again. "I don't recall." "You don't recall one committee member?" "It has been some time." "How many members were on the committee?" Silence. I leaned forward. This is the part people later described as anger. It was not anger, not the ordinary kind. It was something colder. Anger flares. Duty settles. "How many members," I said, "were on the committee that approved your dissertation?" His lower lip trembled once. Barely. "There was no formal committee." "No formal committee," I repeated. "No." That was enough. I struck his testimony. All of it. Not a paragraph, not a phrase. All of it. I instructed the jury, carefully and immediately, that the witness's testimony was to be disregarded in its entirety, that academic credentials had been materially misrepresented, that the foundation for his expert opinions had collapsed, and that they were not to consider any opinion he gave on bloodstain pattern analysis for any purpose. Then I excused the jury from the courtroom. The moment the door closed behind them, the room changed species. Mr. Halpern started first, talking fast, asking for time, asking to brief the issue, asking to recall other witnesses, asking for anything that sounded like delay. Miss Ruiz asked for sanctions, for referral, for a curative instruction stronger than the one I had already given. Dr. Kessler sat in the witness box and stared straight ahead, as if stillness might pass for dignity. I did not let the lawyers bury the obvious. "Bailiff," I said, "the witness will remain." Dr. Kessler finally looked frightened. I advised him of his rights regarding potential perjury exposure. I appointed counsel for the limited purpose of that inquiry. I ordered the record preserved. I ordered the state to produce every prior case in which it had offered him as an expert in my jurisdiction. Mr. Halpern tried to explain that the prosecution had relied on the resume in good faith. "I am not making findings about your faith at this moment," I said. "I am making findings about this witness's dishonesty under oath." He stopped talking. When the jury returned, the state looked smaller, not weaker, smaller. There is a difference. Weakness can recover. Smallness is what happens when borrowed authority is stripped away and the room sees what remains. The prosecution tried to proceed on the remaining evidence. It had photographs, it had officers, it had a medical examiner. What it no longer had was certainty, and certainty had been its whole theory. Without Dr. Kessler's reconstruction, the state was left with the plain facts it had tried to outrun. Forced entry through the kitchen door, a pry bar on the floor within arm's reach of the intruder, bruising on Daniel's forearm consistent with a struggle, a torn shirt collar, a 911 call made by the shooter himself, and a single shot fired in a cramped kitchen after midnight while his family was upstairs. Facts do not strut. They do not carry laser pointers. They do not say scientifically impossible. They just remain. Ms. Ruiz's closing argument was not long. It did not need to be. She stood in front of the jury and held up no charts. She reminded them only of what they had seen with their own eyes. A witness who sold himself as a doctor and turned out to be a salesman, a theory that depended on jargon and collapsed under one question, and a man who called for help instead of hiding what he had done. Then she said one line and sat down. "You don't lose the right to defend your life because somebody in a suit invents a vocabulary." Mr. Halpern's closing was disciplined, but the force had gone out of it. He argued inconsistencies. He argued caution. He argued that fear can become excess. All fair arguments. But the center had failed. Once a jury sees the state reach for counterfeit certainty, every honest point made afterward must drag that shame behind it. I charged the jury late in the afternoon. They were out less than half an hour, not guilty. Daniel did not react at first. Some people expect tears, some people expect collapse. He just sat there, as if his body had not yet received permission to believe what his ears had heard. Then his wife leaned forward, touched the back of his neck, and his shoulders dropped an inch. Just an inch. It was enough. I thanked the jurors for their service. I discharged them. I watched them leave past the rail where Dr. Kessler had once sat like a man above contradiction. He did not look at them. Afterward, when the room had mostly emptied and the lawyers were gathering the last of their papers, I stayed on the bench a moment longer than usual. Not for drama, for memory. Because I have lived long enough in courtrooms to know the danger is not only in the criminals who walk through the door. It is also in the people who learn how to costume themselves as truth. A tie, a title, a resume with enough syllables to scare lazy people into surrender. That kind of fraud is poison to justice because it flatters the system while it feeds on it. You want to know what stayed with me? Not the fake doctorate, not even the price tag on it. It was the speed. How quickly a room can tilt toward a man who sounds certain. How quickly fear can be dressed up as expertise. How quickly a legitimate claim of self-defense can be smothered under language designed not to clarify, but to intimidate. And how little it can take to puncture the whole performance if one person in the room refuses to be bullied by a title. Name the campus. That was it. Not a speech, not a revelation from the ceiling. 5 words. And because the lie could not survive the smallest demand for specificity, everything built on top of it came down. I have been asked since whether I was angry. I was. But anger is cheap. Anybody can feel anger after the mask slips. The harder thing is restraint before it does. The harder thing is sitting still while the wrong person looks powerful, while the truthful person looks cornered, while the jury leans the wrong way, and waiting, because the law requires waiting, until the record gives you something you can strike like iron. When it finally did, I did not need many words. That is another thing people misunderstand about judgment. Real authority does not grow louder. As it gets surer, it gets shorter. Overruled, answer, no, stricken, remain. Those words did the work. And Dr. Kessler? He left that courthouse without the borrowed shine he brought in. The referral was made. The transcript was preserved. Other cases were reviewed. What followed for him happened where it was supposed to happen. In the cold light that comes after a lie has been dragged into the record and nailed there. As for Daniel Mercer, he went home that night to a house that had nearly become a grave, twice. Once from the man who came through the kitchen door, and once from the man who came through the witness box. The first threat carried a pry bar. The second carried credentials from Google. If that sounds harsh, so be it. A courtroom is one of the few places left where words still carry weight because they are sworn. If a man comes into that room wearing a title he bought from a website and uses it to help the state take another man's freedom, then harsh is not the problem. Leniency is. I have no patience for counterfeit expertise. Not in medicine, not in science, not in law, not anywhere a human being can be crushed by it. And I will tell you one final thing. The law did not save Daniel that day by magic. It saved him because someone paid attention when the details stopped fitting the costume. Because a lawyer asked for 10 minutes. Because a judge allowed one more question. Because a jury was willing to admit it had nearly been fooled and then correct course. That is justice at its most human, imperfect on the way there. Vulnerable to theater, vulnerable to ego, vulnerable to money, dressed as scholarship, but still capable, when pressed hard enough by truth, of righting itself. Barely, and on some days, barely, is the difference between a verdict and a life. So when people ask me what I remember most from that trial, I do not tell them about the acquittal. I do not tell them about the fake university. I do not tell them about the $2,900 doctorate. I tell them about the silence after the question. Name the campus, because in that silence, the robe, the witness box, the exhibits, the polished shoes, the practiced voice, the expensive words, all of it lost its power at once. And when a lie loses its power in a courtroom, you can hear justice coming before it speaks.